Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle, and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 138 of the NCDWI Guy podcast. On today's episode, we are talking about mistakes. Henry Ford once said, "The only real mistake is the one from which we learn nothing." Let me read that again. The only real mistake is the one from which we learn nothing. I think that is an important quote because on today's episode, we are talking about mistakes of law and mistakes of fact made by a police officer during a traffic stop and the implications of that mistake of law or mistake of fact in terms of the validity of the stop itself. And one thing that I would remind the court is that the exclusionary rule, the judge's decision in terms of whether to grant or deny a motion to suppress, yes, it needs to be based on the law. That decision coming from the district court judge or a superior court judge needs to be based on the law. And so it needs to be foundationally solid in terms of that decision. But also, if you allow the officer to basically or the state to proceed forward with prosecution, despite the officer's mistake of law or mistake of fact, you're sending a very clear message that this type of mistake is to be tolerated in the future. And that is not something that we generally want to encourage, right? We want to promote great police work. And so the value of the exclusionary rule in a very real sense, especially when it comes to mistakes, is so that the state can be held accountable and change its ways going forward in investigations. So I would put that out there to the court, whether you use this quote from Henry Ford or put it into your own words, that it is in the court's power by using the exclusionary rule of suppressing all evidence post-stop because the stop was invalid based on this mistake. It's within the court's power to hold the state accountable and therefore to avoid this type of investigation being allowed into the future. So I think that's an important thing for you to emphasize in any argument. So on today's episode, we are talking about mistakes of law and mistakes of fact. And there is a United States Supreme Court decision. We often don't have a U.S. Supreme Court decision that is on the books that is directly out of North Carolina, but we actually do have one today that we will be talking about. And I hope I'm pronouncing this right. It is Heien versus North Carolina. And in that case, Justice Roberts issued the majority opinion and basically was looking at mistakes of law, but also kind of in dicta mistakes of fact as well. So it deals really with both. And what the kind of important thing to note is that when it comes to the exclusionary rule, when it comes to a Fourth Amendment issue, we always start with reasonableness, and the court in Heien reminds us of this. So in Heien, this is, again, a North Carolina case. There was a stop by an officer based on one of the tail lamps being out on the defendant's vehicle. One brake light was working, the other one was not working, and so the officer, believing that both had to be working, initiated a traffic stop. But the actual statute in North Carolina when it comes to tail lamps, and this has now subsequently been amended, so it's no longer an issue. If this comes up, you're probably not going to have a great argument, despite Heien not finding this to be a mistake of law that would activate the exclusionary rule. But the way that the law was written, the statute was written in North Carolina, it really basically said that only one tail lamp, one stop lamp needed to be activated. It was somewhat unclear, but basically the statute is that the vehicle must be equipped with a stop lamp on the rear of the vehicle. So again, one of the two lamps was working, the other one was not. So there was no actual traffic violation. And so the court basically in Heien had to decide, well, was this mistake of the law by the officer reasonable, or was the mistake of law unreasonable? In its decision, Justice Roberts points first to the fact that when we are looking at the Fourth Amendment, quote, the ultimate touchstone of the Fourth Amendment is reasonableness. And that really is where the rubber meets the road in arguing both a mistake of law and a mistake of fact. The defense on these type of issues is arguing that the mistake of law or the mistake of fact was unreasonable. The state is arguing that the mistake of law or the mistake of fact was reasonable. The court in Heien, the Supreme Court in Heien, said, quote, to be reasonable is not to be perfect. And so the Fourth Amendment allows for some mistakes on the part of government officials, giving them fair leeway for enforcing the law in the community's protection, end quote. So that is language that you may see the state focus on when it comes to these type of issues being litigated in court. To be reasonable is not to be perfect. To be reasonable is not to be perfect. So they may use that language or some sort of similar sentiment when saying the mistake of law or the mistake of fact was okay. It was a reasonable mistake. Officers aren't required to be perfect. Your Honor, this was a reasonable mistake. So be aware of that language. But the court in this case, Heien, the Supreme Court, basically said there's really no difference between a mistake of law or a mistake of fact in terms of what the mistake does under the exclusionary rule, under the Fourth Amendment. Both a mistake of law and a mistake of fact activate the exclusionary rule if the mistake is unreasonable, and neither activate the exclusionary rule if the mistake is reasonable. So here is some helpful language from the court. This is from the Heien decision. Quote, reasonable suspicion arises from the combination of an officer's understanding of the facts and his understanding of the relevant law. The officer may be reasonably mistaken on either ground, whether the facts turn out to be not what was thought or the law turns out to be not what was thought. The result is the same. The facts are outside the scope of the law. There is no reason under the text of the Fourth Amendment or our precedents why this same result should be acceptable when reached by way of a reasonable mistake of fact, but not when reached by way of a similarly reasonable mistake of law, end quote. So effectively, all that is to say, mistake of fact and mistake of law by the officer are treated the same. Again, whole question is reasonableness. Was the mistake of law reasonable? Was the mistake of fact reasonable? The court does go on to say, and this is language that the defense should pay close attention to. So in your argument, this would be language from the Heien decision that you may want to quote from. Quote, the Fourth Amendment tolerates only reasonable mistakes, and those mistakes, whether of fact or of law, must be objectively reasonable. We do not examine the subjective understanding of the particular officer involved, end quote. So the standard of reasonableness is an objective standard. Would a reasonable officer in this particular officer's position have made this mistake? We don't care really anything about the subjective officer's kind of reasons for the mistake. It's we're looking at it through the eyes of an objectively reasonable officer, viewing the facts or evaluating the law in this particular circumstances. So make sure that you're clear about that. The standard of reasonableness is an objective one, not a subjective one. This language is particularly powerful from the Heien decision for the defense. Quote, an officer can gain no Fourth Amendment advantage through a sloppy study of the laws he is duty-bound to enforce. I'm going to read that again. An officer can gain no Fourth Amendment advantage through a sloppy study of the laws he is duty-bound to enforce. So sloppy police work should not be rewarded. And that, I think, is something that we want to really characterize when there is a mistake that is made. If you can characterize that mistake as sloppy, that is what you want to do. Recently, we had a client that was pulled over because the officer ran client's plates. The plates came back showing that the registered owner of the vehicle had a revoked license and initiated a traffic stop. Well, you may think, yeah, that makes sense. I mean, if the registered owner is showing as revoked, likely the stop is going to be valid. And so therefore the officer is justified. The issue in our case is that the license plate was the incorrect plate. The officer, whether it was CJ Leeds or some other source that he was getting information from, put in the wrong license plate number. And so even though our client had a valid tag, had a valid driver's license, there is a belief on the officers, a mistaken belief of fact that the registered owner of the vehicle's license was revoked because he had plugged in the wrong plate. In my opinion, that is a unreasonable mistake of fact because it's based on sloppy police work. Not only is there sloppiness and you only have to enter, 7 characters at the maximum on a North Carolina plate in order to get a tag run. But additionally, the tag information that was coming up was likely very different than the vehicle this was on. So there should have been some other warning signs of, hey, that, the make and model of this particular tag aren't even matching the make and model of the vehicle in front of me. And again, I don't know if that was, happened to be the exact kind of make, model, color, but I assume that there was some issues in terms of the factual discrepancies that were showing on the tag information versus what the vehicle was. So again, when you're arguing this mistake of law, mistake of fact, try to chalk this up as sloppy police work and then use that language from Heien to kind of back that up. So in Heien, the court ultimately found that the officer's mistake of law, that the requirement for only one brake light, where the officer thought there needed to be 2, was a reasonable mistake of law, and therefore the stop was valid. So the Supreme Court of the United States said that is a valid mistake of law. In terms of mistake of law and mistake of fact cases that are North Carolina specific, I think, again, what you want to focus on in these cases is chalking this up as poor police work, sloppy police work, when you're defending a client where there is a mistake of law or mistake of fact issue. I'm going to point you again to James Davis's DWI trial notebook, a primer for the North Carolina practitioner. This was literally just updated. I'm seeing November 9th. So within the past month, I mean, you're constantly getting updated. Hats off to James Davis for always adding to this primer and making it very, very much a constantly updated project that he has put out there. I've referenced this a number of times on the podcast in the past, but if you want to find this, go to davislawfirmnc.com, and under James Davis's bio, if you click on his bio, you'll see the DWI trial notebook as one of the first resource materials that is on his particular bio page. So it's a very powerful, I use this all the time when arguing cases, but James has got a number of cases, and this is on page 73 of his trial notebook, has a number of cases that are North Carolina specific when it comes to evaluating mistake of law and mistake of fact cases. He points out State versus Jonas, which was decided in 2021, so just last year, that a transporter plate under a car, not on a truck, that was unassigned but not canceled, suspended, or revoked was an unreasonable mistake of law by law enforcement. So if you have got kind of a plate issue with your case, definitely look to State versus Jonas and read all these cases from James's site, as well as the other cases that are on mistake of law or mistake of fact, but we'll just kind of briefly go through a few. State versus Baskins, which was decided in 2018, held that the information from the DMV upon which the drug interdiction officer relied at the time of the stop explicitly provided the vehicle's registration was valid, and the officer neglected to read the information correctly. That mistake of fact was basically not reasonable, and the defendant's convictions were reversed. So again, sloppy police work. If it's just sloppy police work, that mistake of fact, when you're just not reading the information correctly, sorry, that's not a valid basis for the stop. State versus Eldridge in 2016 held that the officer's stop of a vehicle that was registered in Tennessee that did not have an exterior mirror on the driver's side was unlawful when North Carolina does require such a driver's side mirror, because again, this vehicle was registered in another state where there was no requirement for that. The court said that this was an unreasonable mistake of law. So that's a powerful case, because again, the officer, I think one reason why that case is particularly powerful is that it is against the law in North Carolina to not have that exterior mirror. Well, most North Carolina police officers are only going to know the North Carolina law. So if there's another vehicle driving from a different state that doesn't have that mirror, you'd think they would say, well, I know we don't allow that, so I'm going to go ahead and initiate a traffic stop. The court said, nope, Tennessee doesn't require that. This vehicle is registered in Tennessee. Therefore, the mistake of law was unreasonable. So that's a very powerful case, because again, that seems, pretty reasonable. I mean, if you're trained during basic law enforcement training about certain issues in North Carolina, and what the North Carolina law is, you're going out, you're enforcing that on the road. This is against the law. It seems like a lot to ask an officer to know other states' laws. The court says, sorry, unreasonable mistake of law. So I think that that's a really powerful case. State versus McClam, which is from 2007, held that the officer's mistaken belief of the law that the speed limit was 20 miles per hour when it was actually 55 was an objectively unreasonable basis for the stop. That seems pretty straightforward. But I would say that is something that you when you see a client that's, let's say, going through a speed trap or stopped at a situation where the speed limit has just changed, and maybe the officer doesn't realize it. Maybe it's not even a speed trap. The officer doesn't realize that it has just changed down. Point that out. Point out the fact that there's a specific case on point where it says if the officer is mistaken about the speed, that's not a reasonable mistake of law. In State versus Coleman, this is one that's we've actually seen come up a couple of times with clients at the firm. The officer arrested based on an open container in a parking lot was unreasonable. Said the court, it was an unreasonable mistake of law because the law changed in 2000 to forbid the same only on the highway. So this 2013 case, State versus Coleman, the law in North Carolina is that you can't drive with an open container on the highway, but if you have a person that is in a parking lot, a PVA, that in and of itself is not a justification for a stop. So if you have a client that, let's say, comes out of a gas station, they've got a 12-pack of beer, they get in their truck, they open one of the beers, take put it in the cup holder or pour it into a cup, and the officer says, okay, I'm going to go ahead and initiate a traffic stop. Not enough. That is not enough to make a stop based on, because it's not unlawful until you hit the roadway. So the appropriate thing for the officer to do would be let that person pull out of the parking lot, get onto the highway, and then initiate a traffic stop and say, well, I just seen this open container in the car moments earlier. They were on the highway. But if they don't allow them to leave the PVA, and that's what the stop is based for, be aware that that is not enough. So, and the officer's belief that was unlawful wasn't enough. That's not a reasonable mistake of law, says the Court of North Carolina. So important to look at those cases again. Do a full reading of those cases should any of those particular scenarios actually apply in your case, or even if you have a different issue, different mistake of fact or different mistake of law issue, try to incorporate some relationship between your issue and the facts of those cases. Additionally, we had talked a couple weeks back about using the North Carolina Superior Court judges Benchbook, which both district court and superior court judges often look at. And in the stop section of that Benchbook, under section or in section 13 of that stop section, there is a whole section devoted to mistake of law or fact under that. So again, it's always helpful. And so this is under the warrantless stops section of the Benchbook, subsection 13, page 22 of that warrantless stops section of the Benchbook. Go take a look at the Benchbook and just see what the court is going to be looking at, reading from, because again, it's always helpful to know what the judge's background on kind of information and understanding of the legal issue looks like. How, what training have they received? If they're referencing the Benchbook, what particular cases are referenced in there? Because many of the cases that I just referenced to you are not in that Benchbook. So again, you don't assume that the court has heard about these cases. Don't assume that the court is anytime you have one of these issues, don't assume that the Benchbook is giving some sort of full laundry list of every relevant case. It's not. And I believe the majority of the cases in the Benchbook are where there was reasonable mistake and not unreasonable mistake. So reference the Benchbook because I do think that it's helpful to know what the judge might be consuming as these issues are being litigated or during closing arguments. And if you can reference something from the bench book that serves your client in terms of making a persuasive argument or referencing one of the cases, that to me is always helpful, because you can actually point out, in the bench book, Your Honor, this particular case was referenced, or here's the reason why mistake of fact or law needs to be reasonable. Again, whatever your issue is, if there's a way to reference the bench book, try to bring that into the argument. So again, ultimately, what we want to remind the court is that if an officer's mistake is allowed to slide, if they're not held accountable for that mistake, then it's unlikely that mistake is getting corrected. That's just human nature. If you're not kind of punished for your mistake, if there's no repercussions to your mistake, then what would be the reason for fixing the mistake itself? So I think it's important to bring that out. Try to give that kind of persuasive argumentation when you have one of these issues, and hope this information has been helpful to you. Look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.